Do adopted children inherit like biological children? Imagine a family where love is the only inheritance that matters. Now, you might wonder, do adopted children get the same rights to inherit as biological children? Let's explore how inheritance laws work for adopted kids and what that means for estate planning. When a parent legally adopts a child, the law treats that child as if they were born into the family. This means the adopted child has the same rights to inherit from their adoptive parents as a biological child would. If the adoptive parent passes away without a will, the adopted child is entitled to inherit under intestate succession laws. These laws say that children, whether adopted or biological, share the estate equally if there is no will. Once adoption is finalized, the legal relationship with the birth parents ends. This means the adopted child generally cannot inherit from their biological parents unless the biological parents specifically include them in their will. Adoption severs the inheritance rights from the birth family, but it also creates a new legal parent-child relationship with the adoptive family. To make sure their wishes are clear, adoptive parents should create a detailed will. This helps avoid disputes and ensures the adopted children inherit what the parents want. It is also important to note that if the biological parents want to include the adopted child in their estate plan, they must do so explicitly through a will. In some cases, such as step-parent adoptions, the legal relationship with the birth parent might stay intact, which can impact inheritance rights. For example, if a step-parent adopts a child but the biological parent remains alive and has not waived rights, inheritance from the biological parent might still be possible. Overall, once an adoption is finalized, the law treats the adopted child as a biological child for inheritance purposes. They inherit from their adoptive parents just like biological children do. However, they do not automatically inherit from their birth parents unless those parents include them in their estate plans. So, in simple terms, yes, adopted children inherit like biological children from their adoptive parents, but their inheritance rights from birth parents depend on what the birth parents decide in their wills. This legal setup helps protect the family structure created through adoption and makes estate planning clearer for everyone involved.